Welcome to the program. My name is Marty Schenkman, and I'm joined by my colleague, Jonathan Blotmacher. I apologize to Larry Lipoff and to all of you. Larry was to join us for the program. We had some technical issues, and he just wasn't able to. And we'll try to mention some of his comments as we go through. So apologies to all of you and to Larry. Let's begin with just a couple of quick.
Marty.
Yeah.
Marty, why don't you mention that you and Larry and I have an article coming out about this?
Good. Excellent. Thank you. Good point. We have an article coming out. We haven't yet determined where it's going to be published. And what we'll do is we'll post the article to every place that we post the webinar. And if possible, email it out to all of you as well, so that you'll get some of Larry's comments in the article. Thank you, Jonathan. Good point. Just a couple of preliminary comments. The PowerPoint for the webinar is available for download from the web console. You should see an indication for handouts. Just click on that and you'll be able to download it, print it, save it, and do anything you want. The materials are also posted to schenkmanlaw.com on the blog post on the first page. Both Peak Trust, Interactive Legal, and Schenkman Law will post a recording of the webinar and the materials. So if somehow you still miss it, it'll be on all three websites, probably within a few days of the program airing. There's 150 webinars now and growing on Schenkman Law, which you can access anytime, and about 150 plus video planning clips on Law Easy. And hopefully Jonathan will help me add to those in a significant way in the near term. We don't give CLE or CPE credit, but the system will generate for you a certificate of attendance. And if you have any questions, best is to email us. Let me ask Interactive Legal is one of our sponsors to make a quick comment.
Of course. Thanks, Marty. My name is Teresa Bush, and I'm the Director of Education and Support for Interactive Legal. We're pleased to co-sponsor today's webinar, and I'd like to welcome everyone who is attending. If you're not familiar with Interactive Legal, we provide automated drafting solutions and other resources for estate planning and elder law attorneys. And one of the resources we provide is collaboration on new developments in the law by sponsoring webinars like this one to discuss those new developments and how they impact your clients, and then translating that into document provisions when it makes sense. If you'd like more information on Interactive Legal, please visit our website or reach out to us at the email address you see on your screen. Thank you to the panelists for sharing your time and expertise with us today, and I look forward to the presentation.
Just a quick comment. I've never made this offer before, but I've not only been a subscriber and user of Interactive for a number of years, but a fan. If any of you want to hear how I've used it in my practice or why I just feel that document generation is the way to go for drafting estate planning documents, certainly feel free to email me and I'll be happy to help if I can. Our other sponsor for today is Peak Trust Company, and I'm not sure if Nicole made it. Jonathan, do you know if she was able to get on? I don't see the video.
Well, I don't know, but as you may know, Marty, I'm the Director of Estate Planning for Peak, and my nephew and brother run it, and I've been, working with Peak since the inception. Almost all of my family trusts are at Peak, and I know that's largely true for you as well, Marty.
It is true.
Peak is now not just in Anchorage, but it's in Nevada, and in a couple of months, it's also going to be in Delaware. And I do not believe I have ever had anyone I've referred to Peak which has been unhappy with the service and has left. And I think that kind of says it all. So, they offer a full complement of trust services. They're not a bank, they're only a trust company, and they really give you personal attention. Back to you, Marty, or over to Jennifer.
I have had a self-settled trust with Peak since I think 1998. I think I set it up within 6 months of the Alaska statute being enacted, and have subsequently used Peak for scores and scores and scores of clients. I can tell you all that in 2021 and 2020, when we were all stressing to get planning done before the year end because of the fear that at any moment a new tax law could be enacted, which obviously didn't happen, Peak came through with flying colors, getting stuff done in record time, even right up to the end of the year. So certainly something interesting. And we're going to talk, by the way, about the importance of using independent institutional trust companies in the Levine case in a few minutes. Now, one of the things I've tried very hard to do, and I thought is been something that is just, it makes me feel like a good deed, is the featuring of a charity on as many webinars as possible. And it gives me great pleasure and honor for this program to ask somebody on behalf of the American Cancer Society, which is a wonderful charity, to make a few comments.
Thank you so much, Marty and Jonathan, for the opportunity to be on today's meeting and for all you do to support our organization. My name is Jennifer Cayetano, and I'm the Director of Estate and Gift Planning for the American Cancer Society. Our mission is to save lives, celebrate lives, and lead the fight for a world without cancer. We're working to deliver on this mission by attacking cancer from every angle through advocacy, research, prevention, and early detection efforts and patient service programs. Every day at the American Cancer Society, we are helping someone facing a cancer diagnosis. Your clients' contributions are a big part of helping us fulfill our mission. To help you in return, we've created the National Professional Advisor Network, also known as NPAN. Through NPAN, we can provide you with reliable, easy-to-use tools and resources to help your clients make informed decisions regarding their estate plans. Please visit us at cancer.org/NPAN to join our free network and find an ACS director near you. Thank you again to all, and may you enjoy the rest of the meeting.
Thank you, Jennifer. I appreciate it. Let me just add a few comments, because I've done a lot of volunteer work with the American Cancer Society, and it's really an exceptional organization. The statistics are frankly terrifying. 1 in 2 men during their lifetime will be diagnosed with cancer, and 1 in 3 women. This is not something that affects somebody else. There's nobody that has to look very far from either themselves or even their immediate circle of friends, family, and loved ones to find somebody affected by cancer. I can tell you that the research I've seen, the impact. I had a very, very dear close friend who I lost to pancreatic cancer over 30 years ago. My father was diagnosed with pancreatic cancer and survived for quite a significant period of time due to the amazing research that the ACS has done. Even if you know everything there is to know about estate planning, and I don't, that's why I keep speaking with Jonathan so I can learn. But even if you know everything, the NPAN is a great way to show your support. It's a great way to just get information to remind you of the existence of the American Cancer Society. And it literally will take you, I promise, 60 seconds or less to join. And they're not going to sell you things or hustle you or solicit you. So if you're not a member, just go to cancer.org/NPAN. And literally in 60 seconds, you can already have an impact in a positive way by just signing up. So please give some thought to that. We're gonna jump into the webinar and get going. So the Levine case came out quite recently, and some are heralding it as a an incredible taxpayer victory, which it was a taxpayer victory, and that somehow it's going to provide a mechanism, a recipe, if you will, that if you follow, you can absolutely have a victorious split dollar economic benefit plan. And the answer is not quite that simple. There's a number of issues which we're going to talk about in terms of possible gift tax consequences, income tax implications at the end of our program. And we are going to go through Levine and try to talk about what they did right, which was a lot of stuff, some of the open issues. And what we're going to also do is mention on the bottom of slide 9 is I went through the case and I tried to extract, if you will, a checklist of items that the case talked about. So there were things that the case talked about that the taxpayers did A+ and it was good. There are also some things the taxpayers seem to have gotten by on, but maybe if we're planning now that we have the lessons of the Levine case, we might even be able to do better. And we'll talk about that. And third, and I'm going to repeat this in the conclusion at the end because I think it's really important, there are a number of very significant, in my view, comments in the court case by the Levine court that suggest not just how split dollar can be done better, but how planning can be done more safely and better. And we're going to talk about that. So even if you don't feel you do much or any split dollar, I think those lessons are worth listening on to, because they're going to be very helpful. Jonathan, do you want to comment on where we are in terms of the Levine case, in terms of, that it's just one case, there's other negative cases, it hasn't been appealed, we don't know?
Well, all of that is true, Marty. There have been 3 fairly recent cases: the Cahill case, Morissette 1 and 2, and now the Levine case. In some ways, the Levine case is the more important because it's a so-called regular tax court decision, as opposed to just a tax court memorandum decision. In theory, the tax court judges don't have to follow other tax court memoranda decision. And typically you get a tax court memorandum decision when it's very heavily involved with factual matters. But in any event, even though you may be able to point to Levine as having greater precedential effect in the tax court, maybe not in any other court, it's only one of 3. The 2 others were kind of negative for the taxpayer. And we haven't had any court of appeals make a decision yet. And indeed, the IRS may appeal the decision in Levine, and we'll have to wait to see how it comes out. Also, as we will discuss a little later, the tax court has kind of invited the Commissioner of Internal Revenue to perhaps change the regulations relating to split dollar insurance, at least with respect to the economic benefit split dollar form of insurance, so that the case might come out better for the IRS in the future.
And that's significant. So even if you want to follow the recipe and feel that Levine works, maybe the Treasury will, the service will address the regulations and make some of the changes. So we're gonna go through it, and first I'll have Jonathan explain some background on what split dollar in general is in broad terms, and then we'll talk about and explain what intergenerational split dollar is and what makes it a little different than the broad general discussion of split dollar. So even if you have no background in split dollar, this is something that will hopefully get you up to speed in a way that you can not only understand the discussion of the Levine case, but you'll feel some confidence in trying to tackle this area if you haven't done it. And let me interject a comment that I think is going to be important. An awful lot of clients made an awful lot of gift transfers in 2020 and 2021, and even now, when I thought all the planning that could be done was done, it still continues. Many clients have made large transfers to use exemption in 21 and 2020 because of fears that the Sanders or other tax proposals would have reduced the gift exemption. And now, and even then, because in 2026, the exemption drops by half. What that's going to mean is if many of our clients have used up all their exemption, and then the exemption drops for clients that maybe haven't used everything, they're going to not have excess exemption. So clients that may have given a $6 million gift because they didn't feel comfortable doing more, the exemption is going to drop by half. They may lose the excess capacity or excess bandwidth of their exemption amounts. What will that mean? We may see a lot more split dollar in just a very simple application, like split dollar loans to fund ILETs, insurance trusts, simply because clients may not have, especially after the reduction in the exemption, enough exemption to make transfers to support the insurance plans they have. So even if you're not focused on split dollar from the discounting benefit that was achieved in the Levine case, it still may be a very valuable tool. So I think we're going to see a lot more split dollar. Now, I'm going to ask Jonathan to talk about and explain split dollar. Jonathan, if you want me to advance the slides, I will, but I'm happy to leave it here and just let you use your own explanation, which may be better than the short materials on the slide.
Yeah, Marty, let's go back and look at split dollar. And it's an interesting concept, and it was developed by the Internal Revenue Service. And in fact, there were no regulations at all until 2003. But split dollar insurance began in World War II. In World War II, federal interest rates got up to 94%. Think about that, 94%. on income above $100,000. So if you were, say, the president of a company and you wanted money to buy life insurance, my gosh, if you needed, say, $10,000 for a life insurance premium and you had to pay income tax on that $10,000, that means you'd have to pay $9,400 in tax. You might go back and say, well, make up the difference, give me that $9,400. Well, the courts have ruled that when someone reimburses you for taxes, that in turn is income. And in fact, to make the guy whole or the gal whole to pay that $10,000 and pay the tax, you'd have to give them, for that $10,000, you'd have to give them approximately $200,000 of income. Well, a very bright guy out in the Midwest decided that what he could do was arrange for the company and the employee to basically jointly own the policy. And the employer would buy the policy of insurance, and the employer would be entitled to get back the cash value or the premiums paid, and the employee would be able to control the death benefit above the greater of cash value or premium paid. A split dollar insurance means that the proceeds paid upon death are shared or divided. And in a circumstance where the employer is advancing the premiums, the employer is the cash value sponsor, the greater of the premiums it's paid or cash value, and the employee would control the balance. Initially, beginning in 1955 in Revenue Ruling 55-747, the Internal Revenue Service said that the employer was making an interest-free loan to the employee. And it took the position that the employee therefore had income to the extent of the value of the interest-free loan. Unfortunately for the IRS, a few years later, a case came out in the tax court called J. Simpson Dean. Mr. Dean, who was a member of the DuPont family, had a corporation, and he didn't want to take dividends from the corporation because that would be includable in his income. So a lot of wealthy people like Marty do today, rather than sell an asset and recognize income or take a distribution out of your C corporation, they would borrow from the corporation. Well, the J. Simpson Dean case said there is no imputed income when someone gets an interest-free loan. So now going back to the 1955 ruling, where the service said that a split dollar arrangement was an interest-free loan to the employee, it was a Pyrrhic victory. It was an interest-free loan. The tax court had ruled that there is no income generated by the interest-free loan. Well, not surprising, the IRS changed its tune. And in 1964, it came out with Revenue Ruling 64-328. And it said, oh, we got it wrong. It isn't an interest-free loan. It's an arrangement in which the employer is conferring an economic benefit to the employee. And that economic benefit is the amount of life insurance protection which he gets. So again, in the standard situation, the employer buys the policy. The employer gets back cash value or premiums paid. If the employee dies that year, the employee gets to say who gets that excess cash benefit. So let's say the employer buys a policy which is going to pay $1 million death benefit, and the company pays $50,000 as the premium on the life of its valued employee. Well, if the employee died that year, the employer would get back the greater of premiums it paid, or $50,000 of cash value. And typically at the beginning, cash value doesn't grow, it's diminished. Later it may grow, but at the beginning it's small. So in that case, the employer would get back the $50,000, the premiums it paid, and the employee would control the right to decide who would get the $950,000 excess death benefit if the employee died that year. And the IRS said that the employee, therefore, is getting a benefit equal to $950,000 worth of term insurance. And the IRS published a table back in 1955 called the PS58 table, which said, based on your age, gender neutral table, how much it was worth. Well, actually, those rates very high because it was based upon a study done in the 1940s of male smokers. So you can bet that they didn't live all that long, and therefore there was a really high benefit. Later in Revenue Ruling 66-110, and Marty, I hope you're taking notes here. In Revenue Ruling 66-110, the IRS said, well, if the insurance company publishes 1-year term, and those were them rates for term insurance, then you can use those vastly lower. So that's what happened. So you went from, again, without any court saying so, the IRS went from a loan regime over to an economic benefit regime, where the economic benefit would be deemed to be transferred to the employee each year equal to the amount of death benefit that the employee got to control in the event of his or her death during that year. Now, finally, in 2003, in fact, it was September 17, 2003, and Marty, you can write that down and check me later if you want. The IRS came out and it said, okay, we know we've taken two different positions on split dollar. We had a loan regime, we had an economic benefit regime. We're going to allow you to choose which one you want. So they issued regulations under 61-22, 1.61-22, which deals with the economic benefit regime. And then it issued a regulation 1.7872. You'll remember that 7872 provides rules for low interest loans. And it said if you have a split dollar loan, the regime will be provided for, and the tax consequences will be determined under that regulation. And basically, you now have a choice, but they are mutually exclusive regimes. You can either have the split dollar loan regime or the split dollar economic benefit regime. What the people in the Morissette case, in the Cahill case, and in the Levine case did is they chose the economic benefit regime. And they didn't do it with an employer or an employee. They had Mrs. Levine through her irrevocable trust, basically Mrs. Levine acting through her irrevocable trust, of course, she owns that property for estate, gift, and income tax purposes because it was a revocable trust. She became the cash value sponsor. She advanced the premiums, and in fact, she paid the entire premium of $6.5 million right in year one. And she was entitled to get back the greater of premiums paid or cash value, but not when she died, but when the insured younger family member died. And sure enough, Mrs. Levine, who was about 90 years old, when she died, there were going to be many more years before the insured would die. And so she had entitlement to a receivable. She was entitled when the insured died to get the greater of cash value or premiums paid. Wasn't entitled then. She had to wait until that person died to get back the greater of cash value or premiums paid. And so her estate valued it, went to an appraiser, and the appraiser said it was worth $2.1 million. Now think about it. Mrs. Levine had put out $6.5 million, and she and the IRS agreed on the valuation that her receivable would be worth $2.1 million. Well, that was phenomenal estate planning. She got almost, $4.4 million out of her estate. And Marty, do you think the IRS was happy about that?
Don't think so.
So what did it do?
So. It challenged it and claimed
and how did it challenge it, Marty?
Under 2036, 2038, and 2703 that this arrangement should be disregarded and we should treat Mrs. Levine's estate as if it owned or had a right to, in conjunction with others, control the insurance or the value that was paid for the insurance.
Yeah, so the IRS, and Marty, I don't know if you want to go on to the next slide, but what the IRS contended was that...
Well, let's finish our introduction to split dollar, and
sure.
then we'll get into the case itself. Jonathan, maybe just explain briefly what loan split dollar is, even though it didn't come up in the Levine case. I think it's an important concept that those that aren't familiar, and folks, if you know all this, we'll be done with the basics in a few minutes. We just thought this would be helpful for some of the listeners. Why don't you explain briefly what loan split dollar is, and then I'll sort of put a little color on this concept of intergenerational split dollar, and then we'll jump into the case.
Sure. Well, again, we have the economic benefit regime, and the way to really look at that is to like a look at Revenue Ruling 64-328, and that's kind of repeated right in the regulations now under 1.61-22. The loan regime, basically, which was promulgated under Section 7872, basically says you can loan money to whoever you want in the family. Typically, it's going to be an irrevocable life insurance trust, which will be a grantor trust, which means under current law, the interest either paid or imputed is not going to be subject to income tax. And the IRS has ruled that if you make a loan to buy life insurance, then you're going to have imputed income equal to basically the amount of the interest foregone on the loan. And the regulations tell you that if you're going to have the loan due when the insured dies, the AFR you use, short-term, mid-term, or long-term, will be based upon the longevity of the insured. So if you are dealing with someone who has a life expectancy of more than 9 years, and almost always if you've got somebody who's being insured, their life expectancy is going to be more than 9 years, you're going to have the long-term AFR. That also means that if the borrower, say the ILIT, which is borrowing it from the cash value sponsor like Mrs. Levine's Revocable Trust, if it pays that interest, then it's not going to have to include anything in as a gift or as income for that matter. Now, the concept, as I mentioned, originally came about between employers and employees, and then the IRS issued a ruling between a corporation and the shareholder. And in the 1980s, I figured, well, the same thing should work for a family situation or a private situation. So I began to arrange for my clients to go ahead and do it. And it's basically a form of premium financing, where the cash value sponsor is advancing the funds to go ahead and pay premiums of insurance. And I had a number of my colleagues come in and say, "Oh, we understand you're doing this." And I said, yes. And I explained why I was certain that it worked. And they said, "Jonathan, you're going to tax jail. After you hammer and tong, son, go to your house of worship, say a prayer for forgiveness, and leave town." Well, actually, I went to my friend Art Cedarbaum, who was a partner at Patterson-Belknap, and I said, "Art, the IRS, for reasons I don't understand, is very suspicious of me. So what I want you to do is to turn in this request for ruling, and let's find out what the IRS thinks about private or family split dollar, where basically you have the economic benefit relationship between two family members or a trust in a family member." So Art turned in the ruling, and within 6 months, we came back with a ruling 9636033. It was on the prior screen, I think, Marty. But 9636033, and I've named the number of pets and family members 9636033 because it was so important. The IRS said the principles we put out under 64-328 in the employer, employee, and the shareholder corporation context also applies in the family context. Now, our dear friend Marty, Steve Lineberg, came out in his Lisi commentary and said, "This is outrageous. This is just another case of Blaumacher pulling the wool over the eyes of the IRS. It is never going to work." Well, about 6 months later, Steve was the guest speaker at the New York City Estate Planning Council. And before he began his remarks, he said, "Before I begin to speak, I want to make an apology to someone who's in the audience. And that somebody, Jonathan, is you, because I am convinced now that private split dollar insurance, just like set forth in 9636033, is in fact correct." And then other rulings came down. My dear friend Diana Zadel, without knowing it was my ruling, wrote a wonderful article about it in the Journal of Taxation. So if you really want to become an historic, just an dollar, you can get Diana's article as well, and you can fascinate people at cocktail parties, at dinners, or even at weddings, telling them about the wonders of the history of split dollar insurance.
One of
Now,
the things
Marty, is there anything? Oh, by the
please,
way, what is this intergenerational? I said
I'll go through.
previously.
I'll go through that in a second, but I just wanted to make a comment, and forgive me, but I'm not sure you said it, and I think it's important. One of the things that's great about loan split dollar is if you follow the provisions in the 7872-15 regs on loan split dollar, you have a certain statement filed with the income tax returns saying that you believe that the loan will be repaid, and you follow whatever the few requirements are. The IRS must respect the split dollar loan as a loan. And we all know as estate planners that making family loans can be a dicey shot sometimes, because unless you have, a reasonable expectation of being repaid, unless the interest is repaid regularly, unless you follow all the formalities of a loan and document it, the IRS very well can challenge, and even if you do all those things, they can challenge the validity of the loan and try to recharacterize it as something else. If you adhere to the terms of the split dollar regs, split dollar loan must be respected by the IRS as a loan, which is great security for knowing that the transaction will work. And a key is obviously it's secured by an insurance policy. So it's a wonderful way to finance insurance. And consider what I said, that in 2026, when the exemption goes down by half, we're all going to see a lot more of that. Now, let me so with that background on the two types of insurance, economic benefit, split dollar insurance, economic benefit, and loan split dollar, let me just briefly talk about intergenerational split dollar. So a typical, and this is going to be very much what happened in the Levine case, but in a intergenerational split dollar, let's call it the parent generation, and it'll often be called G1, generation one, makes either a loan or an economic benefit in advance to an ILET typically. And the ILET will buy insurance not on G1's life, because as Jonathan explained, Mrs. Levine was in her 90s. In many cases, the senior generation is much older, and what they'll do is instead buy insurance, for example, on G2, the children. And that's exactly what happened in the Levine case, and we'll talk about it because there's some very interesting factors that help the Levine family win their case. So G1, Mrs. Levine advances funds to insurance trust. Insurance trusts buy policies on the life of a child, G2. Typically, the children in their 40s, 50s, 60s, a good bit younger than obviously G1, and young enough where they're still insurable at reasonable rates, and so on and so forth. And then in many of these cases, the person advancing the funds, in this case, Mrs. Levine, dies sometime after the advance is made, and there's been a discounting, and that's where the challenge by the IRS comes in the value of that receivable in the estate. Now, but for that valuation question, I don't think, and Jonathan, please comment or correct me if you feel differently, that's really the sort of the sore spot with the IRS. The rest of the split dollar and intergenerational split dollar, I don't think there's any real issue with. Do you?
I agree, Marty. Marty, I agree. I mean, as Marty said, in the economic benefit loan regime, the IRS promises that if you follow the structure they have, they will not contend it's not a loan, which they've done in a lot of cases like Santa Monica Picture and the Miller case. You don't have to worry about that. It has to be treated as a loan. The IRS guarantees that. And you can have it treated as an economic benefit regime if you follow what's set forth in Reg 1.61-22. We now have very clear rules on how to do these things. But that does not mean that there can't be some rough spots along the way. And what were the rough spots, Marty, again, in the Levine case?
There's three main sources of challenge, but there's some other issues such as the fiduciary relationships we're going to talk about as well in Levine. But the three-pronged attack that the services used in all these cases is to argue that the entire cash value that the decedent advanced under the economic benefit regime is included in the decedent's estate under 2036. They've argued that the advance is included under 2038, and that the restrictions, the split dollar agreement really being the restriction on the funds advanced, should be disregarded under Code Section 2703, and therefore the entirety of the value be included in the estate. And those were the issues that were brought up in the Levine case, and we're going to talk about each of them separately. So let me introduce them, Jonathan, and make a comment or two about the case, and then let you comment. So the 2036A2 challenge was to apply to include in Mrs. Levine's estate all the value of the property that she had transferred during her lifetime. This is the general 2036A2 rule, for less than full and adequate consideration of money or money's worth. It was not a bona fide sale, and the IRS clearly argued in all these cases that none of these transactions were bona fide sales, over which the decedent, and then this is the key 2036A2 language, alone or in conjunction with, and that was what sunk the ship in Cahill, and we'll talk about it, to designate the person or persons who shall possess or enjoy the property, the income from the property. So let me mention 2038, and then we'll talk about both of them in context of the Levine case.
Marty, let me go back to 2036. 2036A1 is where you retain the right to the income or the benefit of the property. That wasn't the case here. But 2036A2 says if you transfer property during your lifetime and it's not in a full value bona fide sale, and you retain the power to determine who's going to benefit from that property, like I put property in trust, I can't benefit from it, but I can decide which of my kids get it. That's 2036A2. And that applies if I can do that alone, or if I can do it in conjunction with any other person. And in fact, the law is clear that even if that person is adverse to how I want to have the benefits go, you still have 2036A2 inclusion. And so in Levine, the IRS was arguing, Mrs. Levine made this transfer. It's now represented in a cash value. And we think that what she transferred is includable in her estate under 2036A2 because she, in conjunction with the other party, which in this case was an irrevocable life insurance trust for the benefit of her family, could control who got the benefit of the cash value. Now, Marty, tell us about 2038.
One of the reasons that was dicey a little bit in Levine, but the taxpayer won, and we're going to talk about this later when we talk about how to structure a transaction after the Levine case to hopefully succeed, is Larson, who is a business colleague, associate partner of the family, was both the investment committee, was the term used in the trust and in the case, but you could call it an insurance trustee, maybe a simpler term to use, more descriptive, and a co-agent with the two children under Mrs. Levine's durable power of attorney. So one of the challenges that the IRS made is, hey, you had the same people on both sides of the transaction, this should all be disregarded. And that the court did not buy, and we're going to talk about that. Now, in 2038, you include in the estate all the property to the extent of any interest therein, in which a decedent has at any time made a transfer. Underscore the concept transfer. In Levine, as you'll see, that Mrs. Levine never owned the insurance policies. They were purchased and owned solely by the islet. So when the service was trying to argue that there was a transfer, she never transferred the insurance. She made an advance of cash for which she got back the split dollar agreement and the payments to be made under the split dollar agreement, which would be the greater of cash surrender value or the premiums paid. Now, there's an exception for 2038 for a bona fide sale or exchange. And the service argued that this was not a bona fide sale. And the taxpayers argued she gave up the cash and got the split dollar arrangement back. So let's see what the court said about both of these. And the court tackled 2036 and 2038 together. And it said that the insurance trust purchased and owned the policies. Mrs. Levine or her revocable trust, who was the actual entity or trust making the advance, and as Jonathan said, because it's obviously revocable, it's including her estate, there was no transfer of these policies. Neither Mrs. Levine nor her revocable trust had any rights ever to the policy. It was all held from inception by the insurance trust. And they also said the property is also not the receivable itself, because that belonged to the revocable trust and then to the estate. It wasn't transferred. It's what it retained. In other words, the revocable trust, which was for tax purposes equivalent to Mrs. Levine's estate, advanced the $6.5 million and got back this split dollar arrangement, this receivable. It didn't transfer the receivable that it held. It never transferred it. It's what it retained for, received for the cash advance. The tax court held that unless Mrs. Levine jointly held the right to terminate the split dollar insurance policies, jointly, keep in mind that word, with the ILIT that held the policies, she could not, under the terms of the split dollar agreements, ever really access the value of those policies. It wasn't included in her estate. In contrast, and we're going to see this in a few minutes, in the Cahill case, which was a taxpayer loss, the decedent, through the decedent, Mr. Cahill's agent under his power of attorney, in conjunction with the cousin who was a business partner or the son who was the agent, could terminate the split dollar agreement. The language in the Cahill case expressly gave both of them together to jointly the right to terminate the split dollar agreement. Here in Levine, and this is a significant difference in facts from Cahill, only the ILIT trustee, and we're going to talk more about his independence and so on in a few minutes, could terminate it. So on this basis, the court felt that 2036 and 2038 did not apply. Now, on slide 23, the IRS argued that the people were the same on both sides of the transaction. Larson, the business partner, was a co-agent along with the two kids for Mrs. Levine under her durable power of attorney, and Larson, the business partner, was also the investment committee, if you will, the insurance trustee that could decide when to terminate the transaction. Now, one of the comments that we're going to make later when we talk about how to plan better post-Levine, if you're trying to do this type of transaction, is try to do whatever you can to have complete independence of the fiduciaries on both sides, all sides of a transaction. It would have been better in the Levine case for Larson not to have been a co-agent and just have been the investment committee or the, if you will, insurance trustee. But that wasn't held against the Levine family, and they were victorious nonetheless. And we're going to talk about the independent fiduciary obligations that Larson had and his sophistication that may have helped sway the court. But again, it's preferable to have complete independence. But they won on the 2036 and 2038 arguments.
Marty, let me ask a question. Mrs. Levine did not retain a right, according to the papers, even with the trustee of the ILIT, to terminate the trust. And yet, in the, I guess it's the Cahill case, the taxpayer with the estate of the taxpayer with the other party could terminate it. That was right in the contract.
In conjunction with the trustee, they had to jointly do it in Cahill, if I recall correctly.
Right, but Marty, didn't Mrs. Levine and the irrevocable trustee, Mr. Larson, didn't they have the right as a matter of state law to terminate it? Can't two parties to a contract always do a novation and terminate the arrangement regardless of what it says?
Yes.
And if that's the case, and I'm reasonably certain that's the case, then what does it matter if it's in the documents or it's not in the documents, since even if it doesn't say so, you have the right under state law with the other party, in conjunction with the other party, to terminate the arrangement.
Helmholtz.
Yes, there's and the tax court in Levine really gets on this, and it's worthwhile being aware of this. There's a very famous Supreme Court case called Helmholtz, Helmholz, and that's a Supreme Court decision where the court said that a right that you get under state law to terminate a trust, if it's not retained in the document, it's just conferred by state law, we're going to ignore it. And there is another case kind of like that called the State of Tully, which was decided originally by the tax court and then the Court of Appeals, in which they said the same things. If it's just a matter of state law giving rights, as it was here between Mrs. Levine during the balance of her life time and the trustee of the islet, who was the counterparty in the split dollar arrangement, the fact that it arose under state law, we're not going to count that. One of the lessons here is you do not want to provide, and I don't care what type of transaction you're doing, whether it's split dollar, no matter what kind of arrangement it is, you do not want to explicitly have your client retain the right alone, and even with the conjunction of any other person, to go ahead and to be able to terminate the arrangement. Now, let me drop a footnote here, and that, Marty, is the Powell case. Because in the Powell case, the tax court said, and that was a unanimous decision, that because Mrs. Powell, as a partner in the partnership, could, together with the other partners, distribute everything out of the partnership, she had the right, not alone, but in conjunction with the other partners, to terminate the arrangement. So the underlying assets which were in the partnership would be includable in her estate without any discount whatsoever. So it's very, very dangerous to have that right. Now, by the way, in Powell, it wasn't explicitly stated. It was just a matter of state law. So we have kind of a strange situation here on it. But I think if you're setting up an arrangement where if your client has the power alone or in conjunction with others to terminate the arrangement, you may be in for a very nasty surprise.
Clearly, one of the differences between Powell and Levine is in Powell, it was awful facts and things were not done well. In Levine, a lot of the facts were quite good, and as you'll see, were done quite well. But Jonathan, from a technical perspective, what's the difference between the state law right that Mrs. Powell had versus the state law right that Mrs. Levine had? Why is there such a dramatically different result on that issue?
Well, Marty, arguably there shouldn't be such a distinction, but what I've told people who are now doing things like family partnerships is you do not want your client to be in a position to participate in decisions to liquidate the partnership or to make distributions. And if you do a family partnership and your client is a partner, and maybe even if you put in that this particular partner has absolutely no right to participate in decisions to make distributions and no right to participate in the decision to liquidate, the IRS may come back, but you've got that right under state law. And then you're back to arguing Helmholtz and maybe something like Tully, where you want to do it. My advice is do not give the client that power at all, or if you do give the power to the client, you want to get rid of it right away. Now, what I've done is if Marty came to me and said, I want to do one of these family partnerships, how do I avoid Powell? I'm going to say, well, Marty, why don't you create a partnership of which Patty is a partner, and you make contributions to the partnership, and give Patty a unilateral right for a while to withdraw all the property from it. That should qualify for the marital deduction. But now Patty is not the transferor. And remember, 2036A2 applies where it is the transferor who has the power to terminate or control the beneficial enjoyment of property alone or in conjunction with any other person. Patty isn't the transferor. And Mitch Gans and I wrote this up many, many years ago, and we are actually, Marty, shocked that people haven't followed that advice. If you're married, do it for your spouse. It should qualify for the marital deduction. Again, your spouse, we're assuming, is a U.S. citizen, and that should avoid that problem. And Marty, maybe that could even be done for a split dollar arrangement if you think that the IRS might come back in a Levine type situation and try to argue that someone had the power to terminate in conjunction with other people. Of course, Mrs. Levine, I don't think, was married, so it would be a little tough for her to do it. But in other circumstances, maybe have it done for the spouse.
Let me make two comments, and then we'll get on to 2703 and move forward. One, I think the court, if you read the opinion, and it was well written, it's worth reading the Levine court case, because I think there's some very good information in there about planning generally, in general planning cautions. But the court seemed to say, as I read it, as I understood it, how far can we go? The mere fact that you could have the right under state law to go out and change something, should we let the service presume that anything you could do under state law, you've done. How far can you go down that path before it's just not reasonable? And I think they kind of drew a line here and said, you can't assume just because the parties could get together and change a binding agreement that gave Mrs. Levine no rights, that they're going to change that. And I think that was very important for the taxpayer victory. I struggle to differentiate that analysis versus what happened in Powell, and that's, I don't think we really have the time to go through it. But I think that maybe it's a very fine distinction, or maybe it's a distinction without a difference. I'm not sure. But I think, caution is clearly in order. And I think, again, as I said a few minutes ago, one of the things that helped the Levine family was they really were very methodical and very careful, as you'll see when we go through some more aspects of the case. And that's a big difference from Powell and Moore and Cahill and a lot of these other cases that just didn't look that way. Now, in terms of 2703, the IRS argued that the restrictions in the agreement should be disregarded. And the court said, listen, and the taxpayers argued and the court agreed that, 2703 only applies to the assets owned by the decedent. She never owned the insurance policies. They were purchased from inception by the islet and owned by the islet. So there was no way to disregard that in terms of bringing the insurance back into her estate. Now, let me set up, Jonathan, the next section. And what the next many slides will talk about, and I'm going to go through them reasonably quickly, but I think it'll be helpful to you, is I went through the Levine opinion and tried to extract from it things that not only did they do right so we can model it, but things that the court suggested that maybe we can even do better in future transactions. And I think it's important to note that a number of the things that I'm going to run through, let's say in the next 15 minutes, about this sort of roadmap of how to do better planning post-Levine, are not only applicable to split dollar arrangements, but to a lot of our planning generally. And then what I did is I took those comments about this sort of roadmap and I broke them down into categories, because I thought it would just make it easier for us as practitioners to understand and try to better model our planning in light of the lessons of Levine. And again, understanding that in many of these suggestions, I'm going beyond what the Levine family did, because, hey, if we learn a lesson from the case and can do something better, why not? So these are some general things. First of all, and I said this earlier, the Levine court recounts in detail and mentions many times in various different ways the meticulous attention to detail. They had at the bottom of slide 26, estate planners as skilled as the ones in the family retained. They talked about this in multiple ways. It's critical to do the opposite of what happened in the Smaldino case. We want to be thorough. We want to be careful. We want to be consistent. We want to give attention to detail. Another point that came up, similar point in many points in the case, was how meticulous and deliberate and careful the attorney named Swanson was. Court said Swanson, who was the estate planning attorney, spent a good deal of time thinking through all the advantages and disadvantages, conditions and qualifiers. He put together a PowerPoint presentation for the family, and so on and so forth. This, to me, is vital. Many of our clients either don't want to bother, and lots of them don't want to spend the money on us putting together memos, going through not just the good things, not just the advantages proposed of the proposed plan, but the disadvantages and the conditions. The thoroughness of those memos, I think, was a very important factor in swaying the court, because it showed that the taxpayers understood the plan. They understood what was happening. It showed the detail and thoroughness of the planner. And as an aside, several, there's a recent malpractice case called Wellen. There was another significant malpractice case a few years ago called Rhea. And one of the common themes in these and other cases has been that the taxpayer, the client, claiming that the attorney never explained certain risks to them. But here the court is lauding the attorney for explaining the advantages and disadvantages and the conditions and qualifiers. We should use this as the gold standard of planning and justify it or explain it to our clients based on what the Levine court said, because documenting things will help the taxpayer, and it also helps protect us as practitioners. Plan in advance. Obviously, the sooner before death something's done, the better and more palatable it looks. There wasn't a great deal of difference between what occurred in the Levine case and the Cahill case, which was unsuccessful. And I think that because of all the other positive factors, the court ruled in favor of the Levine family, but we should certainly try to do better if we can. In Levine, this split dollar economic benefit plan was put in place in June and July of 2008, and she passed away in January 2009, not very long after. Similar in Cahill, the policy was purchased in 2010, and Mr. Cahill died in 2011. So I'm not sure there was a great deal of advantage or difference on this particular point in the case of Levine. Next, I'm going to make some comments that pertain specifically to the decedent or taxpayer. Now, this one on slide 30, I think is really important for the taxpayers, and I'll mention a couple of reasons why. And it's incredibly important, I think, to protect us from clients coming back unhappy. Gee, why'd you let me give away so much money? Why did you push me, even if you didn't? Why'd you push me to give away all this money? Why'd you recommend this plan? I need more money to live on. The court noted in Levine that throughout, the independent trustee of the islet, Larson, the business partner, and the Levine children made it clear to the attorney that Mrs. Levine wanted to retain enough money, assets, to maintain her lifestyle until her death, and that they only used what the court called excess capital, the excess of her net worth over what she needed to maintain her lifestyle expenses in the planning. That's a great way to plan. Get financial advisors, the wealth advisors involved to do forecasts to determine what a client might need for living expenses. If you have that backup and there's ever a claim by a creditor that it was a fraudulent conveyance, or by the IRS that there was an implied agreement with the trustee, now you have the corroboration. No, we had a financial forecasting done, and it showed that there was enough money to maintain the donor client transferor's lifestyle. Very, very useful to planning of any kind. Key to the case, and we've talked about this before, and we contrasted it with the Cahill case, is that Mrs. Levine had no rights in the insurance policy. She had no rights to terminate the split dollar agreement. Only the insurance trustee, who was an independent fiduciary, could do that. She had no rights herself in conjunction with others to terminate the policy. Only the insurance trust had the right. In contrast, that is the bottom bullet point on 31 says that in Cahill, the son is agent for Mr. Cahill, and in conjunction with his cousin business partner as the trustee, could have terminated the split dollar plan at any time. The language in the document, the split dollar agreement in Cahill, was very different on this point than in Levine, and that had a significant effect. The next category of roadmap or planning comments that I want to go through have to do with the ILIT, the insurance trust. And forgive me that some of these sound repetitive from different sections, but anything that's repeated was repeated in the case. So if you see or hear some repetition, that is the emphasis the court in Levine put on this stuff. And by the way, it may be a little fruity, forgive me, but some of the points in here, I know there's going to be a number of insurance professionals on the webinar. I actually haven't looked at the list to see how many, but I've highlighted some of the points for insurance professionals in blue just to make it stand out for them. But obviously the entire discussion that we're having is relevant to insurance professionals. Now, as to the insurance trust, I think it's critical to the success in Levine that only the ILIT, never Mrs. Levine, ever owned the policies. And that's important to make sure that the insurance professional does the applications and all the paperwork correctly, because you want to make sure that it was never owned by the taxpayer. That would have sunk the Levine ship here for sure. So that was important. They were never owned by her. They were never transferred by her. The ILIT only owned them. Now, another key thing in the Levine case, and something we can model in cases that we do, is that Larson, the business partner, was a fiduciary. He was clearly acting in a fiduciary capacity. And you want to be careful, because with all the different functions that can arise in a modern trust, some are fiduciary, some are not. This person should be in a fiduciary capacity. He was independent. He was not a family member. He was not a family member. And as Jonathan and I were discussing earlier, he was also a very skilled, capable, knowledgeable, independent person. If you have someone that has no financial or business background, how can they make these decisions? Larson was a bright guy. He was, I think, a controller for the family business years earlier, and he had the wherewithal to serve in this capacity. Now, the one negative, but it didn't sway the court, but if you're trying to model the good things in a Levine type plan, Larson was a co-agent with the two kids and the insurance trustee. And the IRS seized on that and tried to argue that you have on both sides of the transaction, Larson is co-agent, Larson is insurance trustee. Now, mind you, they're different fiduciary appointments with different responsibilities to different people. And I don't know that the IRS argument is correct or not, but to the extent you can have fully independent people, why not? It's got to be safer and better. So if you're structuring such a transaction, the independent insurance trustee, they called it in the case, the investment committee, should not also be an agent. Jonathan?
Yeah, Marty, I think the point you make is critically important. Don't have the same person on both sides, even if they are in fact acting in different roles and you can justify it. Just keep them out of it. Don't make, Mr. Larson, attorney in fact for Mrs. Levine because he could revoke the revocable trust and therefore he could act on behalf of her side of the equation. Get different people in, and as Marty said, it's critically important that you get credible people or entities acting as the fiduciaries. Don't take Uncle George, who doesn't know anything from Shinola, in and say, oh, he was the independent trustee. Uncle George doesn't know anything. Get people who are experienced, who understand what's going on, because that's going to make it much more justifiable to the court.
Now, on slide 35, and I don't want to belabor it, you can read it later, but I kind of speculated, like, how different was this than the Cahill case? Now, the court was clearly convinced for the reasons I said and Jonathan said that Larson was an independent, sophisticated trustee with fiduciary obligation to independent people. We're going to talk about that in a second. But Larson may have been an employee in the family business. He was certainly a partner with the family, and he had known and worked with the family for 50 years. Now, how much different is that than in Cahill, where the trustee of the insurance trust was a cousin and business partner of the son who was the agent under the power of attorney? Again, and I think Jonathan kind of said it, get the most independent fiduciary you can. The Levine family succeeded with what they did, but the more independent, the better. And golly gee, what's more independent than naming an institution? And you'll see in a few minutes, the court was absolutely impressed that an independent trust company, South Dakota Trust Company, was an independent institutional trustee. Maybe you can have, if the independent institutional trustee vets the insurance policy, maybe they'll even be the insurance trustee or investment committee for the trust. And then there's absolutely no issue because no one's going to challenge the independence or that is, that there's a wink kind of wink arrangement with an institutional trustee. It's just not going to happen. So that was really significant. I love this part of the case because my default approach to planning is to always name as the general trustee an institution for all these reasons. And the court went on and on about how important it is. I think for all of us that when you look at any substantive plan, why not name an independent institutional trustee? This was a directed trust. The family could still pick and choose who's in charge of investments. And obviously here with insurance, it makes sense to have an independent person, not a family member. But why on earth not use an institutional trustee to infuse that independence and credibility? It made a big impact, I feel, to the court. And I think that as a profession, we should all lean more towards using institutional trustees than we do. And I know a lot of clients object, the cost, they're not going to be as friendly or as concerned, but that's the whole point. You don't want someone that's friendly, you want someone that's independent and professional. So that's another point to keep in mind. Now, it's vital to the success in the Levine case on slide 37 that the person holding the power acts as a fiduciary. So Larson was expressly a fiduciary acting in a fiduciary capacity. Just be careful because, as I said earlier, there's so many different functions and roles and capacities that we create in a modern trust. You want to make sure that you're not inadvertently or unintentionally saying that someone's acting in a non-fiduciary capacity when you need them to be in a fiduciary capacity. Another critical point to this is that Larson had a different fiduciary obligation as a trustee, the investment committee of the ILIT, than he did as a co-agent under the power of attorney. The insurance trust had the grandchildren as beneficiaries, so there were different independent beneficiaries than who were apparently the beneficiaries under Mrs. Levine's will, so different people. Now, interesting point, and I thought it was, it speaks to the sophistication of the court to have looked at all these things. On slide 38, there were powers of appointment given in the trust, but they didn't defeat the grandchildren as different independent beneficiaries to whom Larson owed a fiduciary duty. Had the children been given the right to exercise a lifetime power of appointment that could have defeated the grandchildren's right, the result may have been different. So again, caution is in order. You got to pay attention to details. We all tend to use lots of different powers of appointment in trusts, not only to address GST issues, but to infuse flexibility given the incredible changes in not only the tax law, but in the world we live in. Be careful that those flexible techniques of powers of appointment don't undermine what you need. Keep in mind that the IRS really tried to make hay out of the fact that Larson was both a co-agent and ILIT trustee, and they tried to argue that he was on both sides of the transactions. And Jonathan summed it up earlier. Just use different fiduciaries. I highlighted it in yellow because I agree with Jonathan. I mean, why not be more careful? We've already talked about that. Now, next topic, in just a few more minutes, we'll wrap up this roadmap section, and then I'm going to have Jonathan go through a couple of the tax implications that are quite important. The next few comments relate to the split dollar loan agreement itself. Now, Jonathan has already made some very important comments on this in our earlier discussions, that you do not want to have anywhere an indication that the taxpayer, the person advancing the funds, Mrs. Levine in the Levine case, in any way had any right in conjunction with anybody, and certainly not alone, to terminate the agreement. Well, not only did the split dollar agreements clearly specify that only Larson as the investment committee of the ILIT could terminate the agreement, but the recitals expressly said that they don't want to have any incidents of ownership of the insurance in Mrs. Levine's estate, that she has no rights, that only the insurance trust and no one else could terminate the arrangements. So, not only should you be careful how you draft it, I like the idea of what they did in the Levine case of putting in recitals, making it eminently clear what it is that was intended, and what was intended was exactly what the court wanted to hear. And again, this was a key fact, only the ILIT could terminate it. The court said the split dollar arrangements that it analyzed in Morissette and Cahill were different. And when you look at the language, it said the donor and the trust may mutually agree to terminate the agreement by written notice to the insurer. That did not exist in Levine. This was a key fact. Had this been different, the case would have gone the other way, I believe. So watch the precise language that's used in all of the documentation. Don't be cavalier about it. Another final point, if you take a look, there were some criticisms in the Cahill case about the financing of the transaction in Cahill, and that was kind of supporting the court's argument that they believe that in Cahill, the economic benefit regime would have been unwound rather quickly. Jonathan, am I correct in remembering, wasn't Cahill where they found an email suggesting that they should wait till after the gift tax audit or some of the estate tax audit 3 years before they unwind it? Wasn't that the Cahill case?
Yeah,
Right,
there was evidence that the parties had agreed that they would terminate the whole thing in 3 years. And so although the taxpayer didn't lose on the form in Cahill, what the court said is we're only going to give you a 3-year discount. Because remember, also in Cahill, like in Levine, the decedent's estate had to wait until the insured died to get the money back. And there's a way of doing a discounted cash flow analysis, including the probability of death each year and discounting things back to today, which is how I'm sure that it was done in the Levine case and it was done in the Cahill case. But the court found, no, they've kind of said they're going to turn it off in 3 years. Now, I've been kind of critical of the court in that case because let's say the estate has this right to get the money when the insured dies. And there's kind of an understanding with the other family members that they're going to call it off in 3 years. Unless that's an enforceable right to call it off in 3 years, what we value is the decedent's rights as of the moment of death. So when Mr. Cahill died, what was his right? Well, what would a stranger pay for the right? He's not going to take, a stranger is not going to take into account that maybe the family member would agree that we'll call it all off in 3 years. But in Cahill, the court just said we're only going to give you 3 years worth of discounts rather than, several decades worth of discounts. Very, very important. So when you take a look at these things, if you're a really good practitioner, you have to work with a client all the way through to the end.
I think this is my final comment on the roadmap, and then I'll turn it over to Jonathan. In Cahill, the $10 million advance was discounted 98%, more than 98%, to about 184 grand. In Levine, the discounts are substantial, 6.5 or 6.2 million down to 2.1. But there's a world of difference from a 2/3 discount to a 98% discount. One of the things, this is just me speculating, it's not a technical point, but maybe they went too far in Cahill and they were more reasonable in Levine. One final point. There was a rational purpose for the insurance plan other than discounting. The court in Levine was very impressed by and noted that the insurance that was purchased on the kids' lives was purchased for a real independent reason. The children had significant estates of their own and no planning. The children had large real estate holdings, right? Illiquid. So buying insurance for the kids made sense in its own right. In some of the fact patterns that we all see, when the parent generation, G1, buys insurance through a split dollar arrangement on G2, the kids' lives, the kids may have insignificant assets and it's just a device to shift value to the kids. But here there was a real independent logical reason for the purchase of life insurance on the kids. It made sense for their planning. And the court said we find him, meaning the estate planning attorney, credible when he said he also viewed the insurance trust as something that the kids, Nancy and Robert, could use in their own estate planning. So legitimate, independent business purpose. We all want to take steps to corroborate that. Now, Jonathan, why don't you take us home and talk about the gift argument, the Q-tip, and the income tax implications. 3 important points.
Yeah, this is pretty important. As I said, split dollar began, the IRS benefit equal to interest-free loan or to the economic benefit, which came up in Revenue Ruling 6-328. And a lot of people think that that annual benefit also applies in a family or gift tax context, but I don't think it necessarily will. And in fact, Mrs. Levine advanced the entire $6.5 million at day one. Now, if you make a transfer and you get back something else, you've made a gift to the extent you haven't gotten back full value. Well, my guess is that when Mrs. Levine did this transaction, she put out $6.5 million. She got something back which was probably worth less than the $2.1 million. Why isn't that a gift of the difference of the, the $4.4 million differential? The IRS, I think, was asleep at the switch on that. And in fact, Judge Holmes of the tax court in Levine suggested to the commissioner, maybe you need to change your regulations. I'm not sure they do. Remember, if I give Marty $1,000 each year for 10 years, then I've made 10 gifts of $1,000. But if I say to Marty today, Marty, I am going to give you $1,000 a year for the next 10 years, if that is legally enforceable, it's not a gift each year, it's a gift a day. And the case you want to look at, and this is really one every estate planner should know, is Copley, C-O-P-L-E-Y versus Commissioner, which is a 1952 decision by the tax court. There, the husband or fiance say, promised his wife that if they got married, he was going to give her money. And the court found that that was a completed gift at that time, and that the gift was all up front. It wasn't what he was going to give her over time. And here, because there was an agreement for each parties, I think you had consideration, which means that Mrs. Levine was bound. And in fact, here, I think it would be a layup for the IRS because she advanced the entire $6.5 million on day one. She didn't say, well, I'm going to pay these premiums over time. But even if she had, I still think her promise, because it was for consideration, it transfer up front, and you make a gift. This is what section 2512B says. To the extent you make a transfer to another person and you get back less than full value in money or money's worth for what you've given away, you get. Mrs. Levine gave 6.5 million. She received a promise to get something back, but even when she died, it was only worth 2.1 million. And I think that's a real danger there. There's another danger. Now, let's assume the United States IRS does not, this case, and, the Levine family got dumb and happy, man, we saved 4.4 million in estate tax. Well, now it had a right, which at the time of death was worth 2.1 million. And let's assume that there was a tax-free step up in basis on that because it didn't represent income in respect to the decedent. I don't think it did. So now the estate has, and her inheritors will have, an asset with a basis of 2.1 million, the estate tax value, which has now been determined by the court. Now, but what happens if they ultimately get $3 million or $4 million? That additional payment above the 2.1 million certainly will be income. Maybe it's capital gain, but there certainly is income. The bottom line is, when you send this up, you have to think through that at the end of the day, you with an income tax problem, even if you are confident that you're not going to have a gift or an estate tax problem.
And I think it's probably advisable to point out in writing to the client that there are gift tax risks and these income tax risks, and it's not clear that you're even going to qualify for capital gains. If this is treated as ordinary income, let's say Biden's Green Book is enacted where they bump up the rates right away to 39.6, you're getting a 40% estate tax savings and a 39.6% income tax cost, and I don't even know if there's a NIT going to be assessed on this. You really, other than time value of money, there may be no benefit. And the reason I'm suggesting you point it out in writing is because the client is not going to be here when this stuff happens in many cases, if not all of these cases. So you want to make sure that the next generation who may have not been involved in those conversations can't say you didn't tell them that there were these issues. They're trying to achieve a significant estate tax savings. Those are the risks that they need to take to try this type of plan. And that's, these comments that Jonathan pointed out are another reason why, you still need to proceed with caution in exercising a Levine type plan. I mean, I think some people have read this saying, oh boy, let's go out and sell lots of life insurance under split dollar arrangements because it works after Levine. Well, there's issues out there. Jonathan, I know we're getting near the end of time, but can you just mention real quick your Q-tip consideration, then we'll wrap up.
Yeah, some people have said, the worst asset for a lawyer to deal with is the Q-tip. You had, the wife has died. She created a large Q-tip for her husband. It's definitely going to be in his estate when he dies. And in fact, it probably won't even be GST exempt. It's kind of the worst and most difficult kind of asset to deal with. What are you going to do? Well, some people have said, why don't you have Q-tip be the cash value, just like Mrs. Levine's revocable trust, have the husband's Q-tip trust do it. Enter in a split dollar agreement with an irrevocable life insurance trust, have the Q-tip be the cash value sponsor. Well, the real problem is section 2518. Section 2518 says if the surviving spouse or the beneficiary spouse of the Q-tip trust gives even $1 worth of the income, the entire trust is at that moment subject to a meeting. And as I said, I think there is a cogent argument the service could make that because Mrs. Levine was not getting back full and adequate consideration when she transferred the $6.5 million, if you have a Q-tip trust due, that's going to as well. The IRS will argue that widower, the beneficiary of the Q-tip trust, gave up benefits, gave up income interest in that Q-tip, and now you have a disaster under Section 2518. I would be extremely cautious in trying to use a Q-tip trust as a counterparty in that kind of split dollar arrangement. And that's my view, Marty, anyway.
Jonathan, we're going to wrap up. Do you want to make any sort of summary kind of comments on the Levine case, planning for split dollar?
Well, Marty, a couple of things you said, I think very much, warrant mentioning again. Number one, please to your clients about all the downsides of the plan. For example, and to be able to get assets out of their estate, that's fantastic, and you may be right, and it works out beautifully. But that means you're not going to get a tax-free step-up in basis. At least most people don't think you can, and that may make the clients very angry. In fact, as Marty knows, in the case in New Jersey, the plan was terrific, and that also happened in the Wellen case. From Mr. Wellen's children's perspective, grand slam what they did. They transferred tremendous value, and it was just great. But at the end of the day, the family sued the lawyers who were involved, claiming that they weren't informed, or maybe claiming they weren't adequately informed of some amounts of it. That's very important. Second, as Mark said, please use independent people when you're doing a tax-sensitive plan. Don't have Uncle George, Aunt Janet, the milkman, the hairdresser. Because I always give them a big tip when I get my hair cut. Don't do it. Have independent, credible people who can articulate what happened and why it happened. It really impressed the judge, I think, Marty, in the Levine case.
Very much so. Let me expand in my conclusion on what Jonathan said. Take it further than just split dollar. A lot of the lessons of the Levine case and from the opinion, I think, are very helpful to planning generally. And what Jonathan just said is, to me, a fundamental principle of getting a plan to be safer. And clients will fight us on it because it's more money, it's not the person I want. Getting somebody that is competent and independent in as many of these different fiduciary and non-fiduciary positions, I think infuses a sense of diligence and appropriateness to any plan. Always better. I love using and encourage you to use, in the Levine case, stressed using independent institutional trustees as general trustees, even in a directed trust. They were impressed by it. It makes sense. You can't have a wink wink with a corporate trustee. It's just not going to be. Using forecasting or modeling to determine the economics of the plan so you can demonstrate that the client has retained enough assets to support their lifestyle expenses for the rest of their life. Great way to negate a fraudulent conveyance attack, great way to negate an implied agreement attack, and a great way to make sure the client is happy with the plan because they're not running out of money and have to go borrow money from their kids. So there's a lot of good planning ideas in the Levine case that I think are translatable across the board. Don't just assume that because Levine was a great victory, which it was for the taxpayer, that you can go out and do an economic benefit doctrine plan without risks. Jonathan has pointed out a number of significant tax risks, and I've pointed out a number of the legal issues that were could have been close calls in Levine. So I think the end and final comment, and I give Jonathan full credit for it. I've used the line before, but this was his, is as the Sergeant Esterhaus used to say in Hill Street Blues, let's be careful out there. Still a lot of risks, a lot of issues, a lot of uncertainty, but it's always nice to see a taxpayer victory. And it's great to see a court case where they really lay out the reasoning to help us evaluate how we plan. So I wish you all good luck and thank you for joining us. I'd like to thank our sponsors, Peak Trust, Interactive Legal, and our charitable, if you will, sponsor, the American Cancer Society. Please join NPAN if you already haven't. And I'd like to thank Jonathan for all his help. And finally, I'd like to thank Larry Lipoff of Cohn-Resnick, who was supposed to be on the call. We had some technical issues, and I apologize again to Larry, and As Jonathan reminded me earlier, we will have an article that 3 of us, including Larry, have written, and we'll try to make that available to all of you so you can see some of Larry's handiwork. Thank you, everybody, and good luck planning. Welcome.